This presentation is about normalised medical rule breaking in ME CFS contexts, the implications for recent UK announcements and our concerns about glass ceilings and unnecessary risks of failure. The presentation will have two parts. The first half will explain the solution that we were calling for and why, and some frequently asked questions. The second part of this presentation will provide possible outcomes of what we're calling for, the importance of the ME scientific consensus for organisational compliance and risk management, and also what this means for PR communication narratives. In terms of background, the United Kingdom All-Party Parliamentary Group on ME released the landmark Rethinking ME report, containing the crucial aspiration to improve health, social care, education and employment opportunities for people with ME and to encourage biomedical research into the causes and treatment of the disease. The Secretary of State for Health and Social Care, Sajid Javid, poignantly intervened in the case of Maeve Boothby O'Neill on social media, a terrible and unnecessary death, and one of too many terrible and unnecessary situations. He has since instituted departmental processes, including a roundtable focused on research which has been held with a number of doctors with ME honorary fellows in attendance, and working groups, complete with collaboration across the governments of the nations of the UK. These developments are of international significance. The ME CFS delivery plan is composed of three working groups which have already been announced. The Attitudes and Education Working Group, co-chaired by Doctors with ME Director Dr. Nina Muirhead and Professor Sir Stephen Holgate. The Living with ME CFS Working Group focuses on patient needs and experience, and the Research Working Group focuses on the research life cycle and what is required to move that forward. The Delivery Plan Task and Finish Group will assemble recommendations from these three working groups and is attended by their chairs. It will also include recommendations and considerations from the All-Parliamentary Group and from Department of Health and Social Care Coordination and Engagement Advisory Groups. Our professional association's concern is that these initiatives will be a failure from a number of perspectives as things currently stand, due to unnecessary glass ceilings in practice and unnecessary risks of failing at the point of delivery. The processes must enable durable change that succeeds at scale, meaning that it must be guaranteed to survive current processes intact. It must be guaranteed to survive future processes intact, particularly intact throughout the multiple delivery layers in the largest employer in the UK, the enormous complexity that is the NHS. The challenge is how to generate change when the literature itself shows us that medic status itself is intrinsically a risk factor in terms of medical law in this field. Put otherwise, being a medic leads to an initial assumption of an irrelevant or dangerous view being held because of the repeatedly quantified lack of education and quantification of erroneous belief systems that are held, where even basic concepts such as the 5% in 5 years recovery statistic are unknown to clinicians, let alone the importance of confirmation bias when considering such a topic. This makes legally unsustainable or even unlawful clinical judgment all too probable in this field. Let me repeat that. Just being a medic is initial prima facie evidence of insufficient professional ability versus ME CFS. This is the challenge to address. The solution is to correctly set up working group tasks for success by directly addressing the root failings of rule breaking, regulatory failure, regulatory capture, and failure of self-regulation. Institutional failures that will continue to perpetuate education shortcomings and deficient attitudes and culture if behavioural change is not made enforceable in granular detail. we call for prescription of a 4-point approach for working group processes and the final delivery plan. 4 criteria evaluated for every problem and every solution addressed by each working group. Obligations professionally and organizationally. Obligations to do something and obligations to not do something. The rights of stakeholders, whether those be patients or taxpayers and their expectations. Risks to patients, professionals, organizations and taxpayers. Or liabilities to organizations, to the taxpayer, the Treasury, or liabilities to insurers, although outcomes are not always indemnifiable when insurers are properly involved. This is how we address decades of failure, neglect, and injustice. Merely documenting needs, mandating staff training, and hoping for behavioral change will not suffice. We are obligated to be honest about what is required for durable organizational change at NHS scale and with the NHS. The terms of reference for each working group have been distributed, defining objectives and scope, essentially the allowed areas of operation and topics for those working groups. They currently do not prescribe an obligations and rights-focused approach to solutions, and may not be immediately open to this. It may be open to dispute or challenge by members of these working groups, which would consume and lose time when there is a tight deadline on these processes instead of productive work. More importantly, this would also lead to future questions about legitimacy of the final delivery plan. This has happened before, following NICE guideline publication, where senior medical organizations demeaned both patients and the scientific community by not taking the scientific consensus seriously and discrediting their work in a joint statement. To address this, these terms of reference documents for the working groups must be updated to prescribe the 4-point approach that we call for, at a minimum. The focus of this presentation is medical settings, but it is also relevant to the research working group to consider the obligations, rights, risks and liabilities of different parties. Discrimination is known to happen in research, often literally based on a researcher's disability. Interference in processes by promoters of low standards is also far from uncommon in the areas of peer review, grant processes, career progression, or even employment itself. The 4-point criteria approach will empower patients with specific rights and healthcare provider obligations, made directly relevant and immediately usable for the realities of ME situations and history. The 4-point approach will also make high-pressure situations clearer and easier to manage. Accident and emergency or other hospital settings are extreme examples of this often, especially for cases of very serious ME, where families and patients have limited stamina to navigate rules, let alone stand against examples of intransigent healthcare providers. It will also empower organizations and management to set the entire process of change on a regulatory compliance footing, managing risk to patients, risks to employers, whether those be reputational, legal, or sometimes uninsurable. And by doing this, by empowering normal regulatory compliance mechanisms, but versus ME, as they would for any other disease. It's not a case of special treatment, but rules should no longer be optional merely because ME is involved. This will allow organizations to address the unusually high risks of frontline clinical and administrative failure when ME is at stake, with growing liability risks for organizations due to increasing awareness of the scientific consensus and increasing availability of expert witnesses informed by the scientific consensus. This is also without mentioning those long COVID ME cohorts who multiply these risks for organizations several-fold. Again, this is made possible by clear specification of the issues in those 4-point regulatory compliance terms, making rights and obligations immediately relevant to ME by the working groups. The 4-point criteria addresses the following structural problems. Firstly, the root problem of regulatory failure, regulatory capture, and abuses of power. Regulatory failure because of what has fallen through the cracks. Regulatory capture because of where medical authority has often short-circuited the importance of science and the normal application of rules and law against the general interests of public health and the taxpayer. This has involved normalised rule breaking, and the lowering of professional standards is all too common when ME is involved. This includes failures to accurately maintain records and failures to accurately communicate with patients. The documenting of appointments or events that the patients do not recognise is too common, and these include examples where the patients are medics themselves and are able to judge them in professional terms. This includes abuses of power, which include punitive abuses of power, some of which we will detail later in the presentation. And many of these injustices are symptomatic of institutionalized discrimination, breaches of rules and policy that only specifically occur because a patient has ME, a disease that meets the statutory criteria for protection against discrimination, and behaviour such as this can be scrutinised under the Equalities Act and the Human Rights Act, but also in relation to the public sector equality duty. Secondly, optionality of change and intransigence is a structural problem. Organisational change requires more than optional change. That is a basic statement of fact when changing how an organisation works. Encouragement and example setting is important on one hand, but incentivization by rules and consequences for rule breaking is not controversial in any other field of medicine, government, or management. Where obligations or rights are not immediately clear, they can and will be optional in practice. This is the reality of ME on the front line as things stand. We know from the literature that the vast majority of medics hold erroneous, contra-scientific belief systems, but in good faith. But the intransigence of medical norms versus the ME scientific consensus is unusually extreme. Much discussion focuses on acceptance of the 2021 UK NICE guidelines, which are important. But even the flawed 2007 guidelines are effectively not accepted by a very large minority of professionals. The refusal to even accept ME's existence, which is symptomatic of not accepting the 2007 guidelines, that refusal to accept ME's existence as a specific diagnosis is a shocking factor that characterizes ME failure. A large proportion of ME patients proactively avoid medical settings as a result, many proactively even avoiding accident emergency if they can. That level of persistent dogma can only be dealt with by mandatory change that goes beyond mandatory education, as the likelihood is that education will be ignored by a sizable proportion of professionals in any case. The immediacy of change, problem 3, is in relation to the real question of how quickly change will come for people who need it now. Riding scientific inevitability has taken us to this point. Healthcare organisations and patients cannot afford to wait for generational change to seep in over years via professional or university education. Patients must not be unacceptable casualties of this reality, and many of these are extremely ill, severe and very severe patients and their families. The 2 points of the optionality of change and intransigence and the immediacy of change are glass ceilings of change that are systematic and structural, built in to the problems that are faced. A fourth problem is that of opaque rights and obligations. It is too common and too acceptable that basic rules are suspended when ME is relevant. Many of the failings and injustices versus ME are already unsustainable. Breaches of statutory, policy, self-regulatory, reputational or moral standards are common. They are the norm for many patients and their experiences. And this includes where self-regulation or professional codes are not applied uniformly, literally, or justly. For example, those which colleges or the General Medical Council would enforce. Many breaches are already addressable by individuals, but ad hoc. It is a game of whack-a-mole, which ill and exhausted families rarely have the stamina to do. Rights and obligations can instead be distilled by the working groups, broken down and made specific to frequent ME injustices, made immediately accessible and easy to understand for real-life contexts. Problem 5, organizational risk management clarity. Differentiating negligence standards of care requires factual information and is an evolving area of law. Also, consent cannot be given to abusive or substandard decisions or processes that breach basic professional standards that would be applied in any other context. Moreover, informed consent is a very tenuous defense to negligence claims when ME/CFS is at stake, and negligence defenses do not necessarily succeed when professional opinion fails logical analysis. There is more detail on this in part 2, the latter half of this presentation. Point 6, political and administrative will is not a definitive answer. The Secretary of State, Sajid Javid, is temporary in his role. These positions are only held for 1 to 3 years. Today he has been in the post for a year. Sajid Javid's invaluable support will not be relevant once he is in another office of state or international position. This must be understood alongside the fact that scientific awareness on the front line has already been proactively undermined in advance. Political will not address frontline services that have been prejudiced against the scientific consensus by medical leadership. The contra-scientific public response of a number of colleges has already harmed patients' standing and scientists' standing, and many on the front line have believed these statements in good faith, made possible by the low educational standards in this field. 7th, the NHS, as mentioned, is the largest employer in the UK. This is a huge problem. Regulatory and compliance functions are split across agencies and bodies, across local healthcare venues, across local areas, let alone national, across bodies in the different nations. Playing whack-a-mole across these is impossible on that scale. And lastly, point 8, other sectors are also relevant and need guidance. There is the private sector, but beyond the private sector, there is also the non-health insurance sector as well, covering indemnity insurance for professionals, critical illness for people who may become patients, etc. In terms of questions that may be asked about this 4-point approach. Firstly, does the UK ME/CFS delivery plan process matter? Yes, enormously. It is a huge achievement that many people deserve enormous credit for. There is much for the medical and research communities to gain from improved access to the facts and higher standards. But it is not necessarily enough as the terms of reference currently stand. There will be a multi-year process of change afterwards. It is a question of how many years, 1 to 25 years, depending on the speed that change seeps in and how mandatory, how required, how enforceable that change is, and how thorough that change is. Leaving optionality and intransigence on the table remains a real risk that dominates many patients' lives, as mentioned before. This is already addressable ad hoc by individuals. As mentioned, there is an increasing number of scientifically informed expert witnesses, but this requires energy that patients and families do not have, and also personal injury claims have to occur within the first 3 years in the UK, which is not always simple with this disease. Working groups that do not deliver rights and obligations for regulatory compliance teams and managers to enforce would again be expecting exhausted patients and families to play whack-a-mole with the largest employer in the UK, the NHS. And such optionality will most likely again be compounded by leaders of other professional associations complaining about the imposition of science and appropriately high standards. This is against the interests of these organizations' trustees, against scientists, and against patients. But we have seen that such contra-scientific activism works in the medium term, with the NICE 2021 guidelines being smeared in the eyes of many busy frontline professionals too rushed off their feet to read the facts or catch up on appropriate and compliant education. The current terms of reference do mention risk, which can be interpreted very narrowly as implementation risk, which is essentially about project management. And it does not explicitly prescribe a rights and obligations approach to drive and enforce behavioral change. The 4-point criteria that we outline replaces glass ceilings with enforceable minimal standards that provide a backstop, requiring behavioral change in specific and immediately usable ways. Is it helpful to talk about rule breaking? The law does not allow a medic to do whatever they wish. This fact is often lost. Patients and patient charities have so understandably been exasperated by rule breaking up until now. The confidence of underinformed professionals and deference to them also undermines rules that protect patients in practice. At its most basic, medics do not define medical law, and this must be reinforced as a priority versus ME. But it is true that medical law often faces a garbage in, garbage out problem, where the medical profession can misinform lawyers, courts, or other processes by supplying their clinical belief systems rather than scientifically and legally sustainable views. This garbage in, garbage out problem is increasingly diminishing due to the increasing number of scientifically informed expert witnesses. Increased education rates will further increase that supply of expert witnesses that are scientifically informed in this field. Secondly, self-regulatory standards also do not allow a medic to do whatever they wish. Rules and standards laid out by the General Medical Council and by colleges demand specific standards of knowledge, behaviour, communication and trust. These do require uniform enforcement, which is a circular problem, as the empirical likelihood is that the enforcers themselves are not sufficiently educated regarding ME. A general phenomenon of lack of education that is well quantified. And lastly, injustices are injustices. Medics are not necessarily scientists and can be captives of their own social and professional norms, as quantified by the literature. But lawyers and the law can similarly be captive of norms that they have before them. Throughout history, it is often the case that fundamental injustices against sections of society were already contestable using law available at the time. Reform and change for these groups was later forced by new clarifications of rules or law, often resolving contradictions. Applications of rules and law in practice can depend on evolving media narratives, social norms, and general awareness, not just legal logic alone in reality. Lawyers and judges are people as well, who read newspapers, have contact with medics who have erroneous belief systems and are subject to human biases. There can be a choice of logic or a choice of how to apply it. The 4-point approach we suggest will require and normalise higher standards, and improved norms and prescribed rights and obligations would be citable in judicial or in other contexts. Clarity that will improve access to legal resource and use of it, but also reduce the need for legal solutions because problems would become less likely due to improved organizational risk management and compliance enforcement and awareness of risks on the front line. With those frontline rights and obligations easier for patients to point at before problems become dramatic. Is the solution really a regulatory compliance enforcement approach? Compliance teams or other management responsibilities manage a 360-degree view of risks across an organization, not limited to regulatory risk. Regulatory risks such as Care Quality Commission requirements, the CQC, or based on policy documents such as the Public Sector Quality Duty or NICE guidelines. It's also not limited that the work of compliance teams or other management responsibilities are not limited to legal precedents alone, some of which are immediately applicable, some of which would or could be applicable. Compliance teams and management also consider reputational risk, that risk of bad media headlines. They consider resource risk, being the risk to time, the risk to budget, and personnel risks. They consider the risks to patients or public health, the risks of actual liabilities, such as compensation for adverse situations. Compliance awareness, that there is a scientific consensus, is also key to all of this, something that we'll cover in part 2, the latter part of this presentation. Second, optionality, perceived optionality, and intransigence has been a consistent problem in this field. If it is optional, it is not a rule by definition. Intransigence and deep dogmatic attachment to contra-scientific views is a distinguishing feature of medicine in ME. As mentioned before, a large minority effectively refused to even accept any of the 2007 guidelines, the old defunct guidelines. Thirdly, having no areas of enforceability or limited areas of enforceability would leave the majority of current patients behind. A large proportion of current patients will not experience sufficient change without rights and obligations that they can point at. A large proportion of those current patients will experience life-changing negative consequences as a result. These negative outcomes for patients, but also potentially with effects then on organizations and their balance sheets, will further compound for every new patient until generation seeps into the medical profession. And again, that is without us even adding the long COVID ME cohorts. And lastly, the current enforceability of rights is already underestimated, but insufficiently clear in practice. They are underestimated because it can be complicated to say what is required for every person in every possible situation. It can be context specific. There are so many ways that patients have had injustices inflicted. But there are those occasions where it is not correct to ask for rights that already belong to a person and are already enforceable. We know this in Doctors with ME from action we have taken to enforce change in large organizations. It can be more correct to state a patient's right to something and to demand formal explanation in relevant legal, policy, and scientific terms as to why that right is being ignored or undermined. But that is not always simple in practice, legally or practically. Having a 4-point process, a 4-point criteria within the working group processes would allow for immediately relevant specific rights and obligations to increase the clarity for patients and their families when dealing with the front line. So to recap, the 4-point criteria would replace glass ceilings on processes with enforceable minimum standards, those glass ceilings being the optionality and intransigence of problems on the front line, and also the immediacy of change that is needed where patients cannot afford to wait for years or potentially a generation, depending on the luck of the patient. So we are calling for the following criteria to be assessed for every problem and solution considered by the working groups. To reiterate, obligations, rights, risks, and liabilities at a minimum considered for every problem and every solution that the working groups consider, and these 4-point criteria would replace these glass ceilings and lead to durable change at scale for the long term and with immediate effect. Part 2 is with more detail on the whats and whys if you wish it. This is where we discuss the possible outcomes, some examples of a rights and obligations focused approach, the importance of the ME scientific consensus for organizational compliance and risk management and liabilities, in essence, some of that being a specific legal element and angle, and what this means for PR communications narratives if there is a holistic approach taken to change. Possible obligations could include the obligations for organizations or professionals to do something, the obligation to require compliant ME/CFS medical education, or the obligation to complete compliant ME/CFS medical education, or the obligation to recognize an ME patient's housebound or carer status. The obligations to not do something could include the obligation not to negate, not to undermine ME status, whether that be status in policy or status in law, as this can affect access to service or treatments or support in administrative contexts. An obligation to not mislead or evade diagnosis is also important, which could require detailed reasons for rejecting or replacing an ME diagnosis, but in terms relevant to ME diagnostic criteria and not just based on a clinician's belief systems. These clinicians' belief systems, which would frequently ignore both the relevant science and the sufficient evidence of harm from ignoring the relevant science, a problem that occurs frequently where a medic prefers, where and if a medic prefers a functional neurological diagnosis such as FND. It is also the case, as mentioned, that it is too common that appointments or events that the patient does not recognize are documented in records and in communications. And as mentioned earlier, to emphasize, this includes examples where patients are medics themselves. Lastly, and strikingly, the obligation to not abuse power and authority. This can sometimes occur where there are inappropriate outcomes from holding practitioners to account for normal and medical and legal standards. We have seen this happen where the patients and family members are entirely correct in their requests and needs. But this can result in the punitive removal of complainants from patient lists entirely, or the removal of medications, the introduction of administrative burdens not applied previously, or the application of identical or analogous abuses of power to family members who have been hoping to help their relatives. Possible rights will largely be corollaries, mirror images of these obligations. There may be additional specifics, for example, in relation to equipment or carers, in particular in relation to the right to not be discriminated against, where the Public Sector Equality Duty or the Equality or Human Rights Act can all already be relevant but awkward to apply in practice. In terms of possible risks to organizations, the risk of unlawful clinical judgment is unavoidably high in this field as quantified by education levels. Expertise procurement risk. Many historical providers of expertise in this field have been obsolete for some years, offering legally unsustainable belief systems out of step with the science. Record keeping and patient communication risk. Record access by patients or use of freedom of information law generates risks, as these can reveal flawed clinical judgment, discrimination, education refusal, and other problems, including beyond an individual patient. Third-party risk is also a consideration, where inaccurate records and evidence from a third-party organization can lead to other organizations unnecessary consequences or potentially liabilities, whether that be within the NHS or in the private sector, including agencies such as occupational medicine agencies who may make record release requests, physiotherapy agencies, local authorities as well, and reputational risk, primarily concerning the media, or the reputational risk of a healthcare provider, an institution, or becoming a teaching aid, a case study of what to avoid. In terms of risks to patients, those essentially would be broken down from 3 primary areas in terms of health, income, and family life. And liabilities to organizations or professionals could be combinations from any of the above 3 obligations, rights, and risks. Awareness of the ME scientific consensus is fundamental to all of this. It matters to medical risk, legal risk, policy risk, and reputational risk. And lack of awareness also has negative impacts in those areas, undermining informed medics, undermining scientists, undermining taxpayers, and undermining patients. The consensus itself is clear about what is known about ME, about what is not known about ME, about what ME is not, and what the future avenues are for ME research. Preferences about which research areas to consider next are discussed like any other field of research. But this general, on balance, scientific consensus is clear for policy, regulatory, and for legal purposes. This consensus is partially hidden from view, though. There is a lack of awareness of the consensus, and that has been fueled by contra-scientific activism by senior medical figures. These actions do not sit well versus repeated reviews of the literature. And this has leveraged misplaced social deference that being a medic equals scientific status, which it does not by itself automatically. Merely writing an article does not imply rigorous science. On the flip side, there is a level of misplaced underconfidence by those people who are not used to asserting that there actually is, that there actually is a consensus. Many people assume that the many grey areas in ME research and the unknown unknowns mean that there is no scientific consensus. This is wrong and dramatically harmful to professions, employers, the taxpayers, and, of course, patients. It is also untrue to say that there is a split in the science, unless one redefines science to accommodate low standards and dangerous opt-outs. Accommodating low standard numeracy or methodology is endemic in this field. Standards that quite literally can be humorous in any other numerate field. Opt-outs of rigor by defining the disease broadly, loosening diagnostic criteria, pre-affecting results is still a problem. And there remains a persistent campaign from certain parts to perpetuate these violations of scientific probity, process, and rigor, hoping that any future reviews are of a similarly poor standard and do not meet the standards of research reviews such as those by the US Institute of Medicine or the NICE Guideline Review. In reality, the split is between patients, the scientific community, and inquisitive medics on one side, and the medical profession's quantified belief systems on the other. Most of these, again to re-emphasize, most of these flawed belief systems among medical professionals are held in good faith and require education. The importance of the scientific consensus to organizations and regulatory compliance is stark. Current risks to patients and medical employers are unusually high. As mentioned at the start of this presentation, the literature repeatedly shows us that medical status itself is intrinsically a risk factor in terms of medical law in this field. An organization cannot reasonably assume that a clinician can safely or lawfully engage a patient who happens to have ME without unnecessary risk generation. An organization also cannot reasonably assume that this clinician will be compliant with all indemnity or other insurance requirements when an insurer is properly informed. This consensus matters for organizational risk management clarity. Guidelines, science-driven standards, and patient initiatives are increasingly important to the law. Medics cannot follow their belief systems regardless of the law. As mentioned, differentiating negligent standards of care is an evolving area of law at the moment, catching up with the modern age across different areas. Diagnosis, communication, and record keeping are the primary divisions. Informed consent is also problematic. The case of Montgomery versus Lanarkshire Health Board established the importance of informed consent. But currently, it is empirically improbable, unlikely, that a medic has the knowledge required to inform a patient of the relevant factors. This makes any assumption of informed consent impossible. It is also worth noting that procuring a patient's consent does not automatically legalize a legally questionable act by a medic. Negligence defenses also do not succeed when professional opinion cannot withstand logical analysis. The case of Bolitho versus City and Hackney Health Authority deepened the reality that medics do not make medical law, again painting a stark picture. Application of professional medical gloss to polish appearance is not sufficient. A legal principle known as the Bolitho gloss after the case. The law in England and Wales now generally adopts the principle that a court is able to reject a body of medical opinion if, in a rare case, it can be demonstrated that professional opinion is not capable of withstanding logical analysis or is otherwise unreasonable or irresponsible. In the case of ME, we have the clarity of the scientific consensus on one side and the clarity of extreme low standards and mistargeted research on the other. This importance of the ME scientific consensus also extends to PR and communications and education campaign narrative. This is largely a mirror image of the importance of the scientific consensus for organizations and their employees. And it is about joined up thinking, focusing on change, going beyond mere awareness and driving change on a basis that is relevant to organizational realities. The key message to repeat is that there is a scientific consensus about what is known, about what is not known, about ME, about what ME is not, and what the future avenues for ME research are, and that this consensus matters for medics and for research. And at risk of repetition, the key points in support of that are that current medical norms do not withstand logical analysis. This fact is of key legal consequence, that Bolitho gloss principle mentioned before, and that there is no dispute in the science. The science is clear, unless we dilute science to accommodate low standards and opt-outs. There is no patient-doctor split. The global scientific community in this field are aligned with patients and are aligned with the majority of medics who are informed. And medical norms must be updated to undo the divorce of medical practice and knowledge from the science. Those key points are fundamental points in support of the scientific consensus. But these communication principles, this messaging can be hugely improved, no doubt. But no space should be given for contradiction of these facts. They must be front and center. Medics deserve it, scientists deserve it, taxpayers deserve it, and most importantly, patients deserve it. And not doing this leaves opportunity and risk on the table, unaddressed, underutilized, and insufficiently understood. Many thanks for your attention.